5-0. Monica Gussman and Curtis Irwin, both are here. Mr. Irwin via Zoom, and this is the date and time set for hearing in this matter. Ms. Gussman filed a motion regarding parenting time. Looking through the file, sir, I noticed you also have a bench warrant for non-payment of child support.
I am trying to do what I can right now to get child support taken care of. I just ended up jumping through hoops for the past 3 months trying to purchase my trailer. I now own my trailer. That way my daughter has a permanent living stable home that she can live in. I've been working on trying to catch up on my bills as well as trying to find a job that will.
All right, well, we'll take that up in a minute. I'm gonna have Ms. Evan get on in a bit and oh, there she is right now. Well, let's take care of that first. Ms. Evans on now from front of the court. Ms. Evan, Ms. Gussman, the plaintiff, had filed a motion regarding parenting time, and in reviewing the matter, it came to my attention that Mr. Irwin had a bench warrant that normally before the days of Zoom, I would not have allowed someone to appear remotely if they had a bench warrant, sir. And maybe we can resolve that prior to the parenting time motion. Maybe we can, I don't know, but I'll at least let Ms. Evan present the circumstances that led to the warrant and determine if the sentence should be imposed and have you report to the jail, or if there should be some other resolution. But Ms. Evan, what's the status of the bench warrant?
Mr. Irwin has a monthly support obligation of $144 child support, $20 medical support for a total of $164 a month. Currently owes the plaintiff $1,514.21. The state $357.87. Fees $298. Total owing, including April's billing, $2,170.08. Last payment received was $20 October 13th, 2022. We received that same amount August 25th, 2022, and a $1,000 bond August 22nd, 2022. This is a fail to comply issued February 8th, 2023. It's a 90-day jail sentence or a $1,400 cash bond.
All right, and did Mr. Irwin show up for the show cause that set the wheels in motion for the bench warrant?
I did not, sir, because at that time I did not have a mailbox or a established place to receive mail. All of my mail was being returned to the places it was sent from, as in DHS, the courthouse, any place I received mail from. As soon as it was sent to my address, because I did not have a key to my box, it was sent back to the sender. I was just now able to purchase the key to my mailbox now that I own the trailer to where I could go. Now I'm able to get my mail.
So you can't have mail delivered to your residence?
For almost a year now, they would not deliver no mail to my box whatsoever. They would not let me get into the back of the box to see if there was mail there. They would not hold mail at the post office. It was all sent back to the place that was sent from. They immediately.
Ms. Evan, did notice of the show cause come back to the front of the court?
It probably did. I can look and see. We did talk January 4th about that issue.
Yes.
And I explained to you that you were going to need to, come up with a way to receive your mail and what was happening. And I explained then that he had missed the show cause hearing and was expected to make payment or the bench warrant would issue. Let's see. Yes, we got the enforcement notice after the hearing. The arrears notice and the notice of the hearing were both returned back also.
So, sir, you've known about the warrant for 2 or 3 months then?
No, I haven't known about a warrant. I haven't been able to get in mail. I just now.
That's happened in January. You must have known something was coming.
I
told you it would issue.
Yes, ma'am, you did tell me that would be issued, and I've been trying to make money to pay it, but I have no job. I'm disabled, trying to get my disability back, but that's becoming a painstaking process in the means of needing to get an attorney.
Well, let me think about this for a bit. Ma'am, what led you to file the motion regarding parenting time?
Journey actually came to me about a couple months ago asking if she could come home every night with me. her words were that she didn't want to go to her dad's no more, and I told her that was not an option, that she still needed to see her dad and her dad still needed to see her. So I just kind of like blew it off. I'm like, we'll just work through it. It won't be no big deal. And then it, like the last month, she's just repeatedly came to me every day asking to come home. So,
Let her finish. I'll give you a chance to speak.
Yes, sir, sorry.
so her and I sat down and we talked, and I was like, well, you really want to be able to come home with mom? I was like, we'll have to do court because dad's not just going to let you come home with me every day. Mom will have to file paperwork and it will take some time. And she was like, yeah, I want to be able to come home, which I had no issues with that anyways, because like I'm fighting with my job right now because of the hours that I'm working. I see my kids 24 hours in a week. That's it. By the time that, like, I have them every other weekend, and then I have them Monday mornings before they go to school, after I get out of work. On Mondays, I see them for an hour on Tuesday before I drop them off at school. And then Wednesdays, my current job, I work until 6 o'clock now on Wednesdays. So by the time between 6 and 7 are my hours. So then I literally only see my kids for an hour because then they go to bed by 8:30. That's bedtime, especially when it's school season and stuff. So I only see them for an hour. And then Thursday, I see them for an hour before school again. And then if it's Curtis's weekend, then I don't even get to see Journey again until Sunday at noon. So it's not really 50-50 because he gets her when I'm at work, because 3 years later, he still don't have a job. So he has her while I'm at work because he don't have a job. So what's the point of paying childcare if he's not working? So she would always go to his house. So I'm requesting on behalf of my 6-year-old daughter and myself that Journey be able to come home with me every night. And she wants to be, when there's no school, she wants to be able to have the option to either stay with her soon to be stepsisters, Hannah and Peyton, or she also wants to be able to go to my mom's or my sister's. And that was her request.
All right, sir, what's your response to that?
She made a similar request to me, except for it was not about all of that. It was about she wanted to have her own bedroom and spend more time with her dad at home. And at my house, she has her own bedroom where she's not forced to share a bed with somebody else or to sleep in a room with two other children. She doesn't have to share or be made to share her food or snacks. She's allowed to have her toys when she wants them. She has a set schedule at my house for bedtime and wake up. And I'm not sure if this matters or not, but the 1 second, this is in cursive and I've got to try to read it. Yeah, I don't want to be a second class parent. I'm a first class parent just as well as Miss Gustman is. And I believe this should be taken in delegation and according that she's telling me that she wants to stay home with me, but she's also telling her mom she wants to stay home with her mom. She's 6 years old and is not sure of what she wants yet because she is under the mental level to grasp the concept of what her mom is trying to tell her. She tells me every time she comes to my house that she don't want to go back to her mom's house. She'll stand in the driveway crying because she don't want to go back to her mom's house. But then again, there are days where she'll get out of her mom's car crying because she don't want to come to my house. But that being said, that's only because certain days she goes to her mother's house, not my daughter, Miss Gussman, which all of her cousins are there, which means she gets to play with them. And on my days, I don't have that option for her to play with her cousins like that. So of course she's going to want to go and stay with her mother so she can play with them. But at my house, she has all the amenities she needs to be taken care of. She has heat, electricity, food. She has her clothing. She has her bed. She has a pigsty of a room because she loves to destroy it. She has everything she needs. So I'm not seeing why I am going to lose my parenting time. I'm not saying you're going to take it, but I'm not seeing why I should lose my parenting time and become a glorified babysitter for Miss Gussman. Because the way that the custody order stands right now, This is something that she had drawn up and put into play because this is how she wanted it. That way it would match her ex-husband, John Fisk's custody order with her son and him for Brody William Fisk. That way at the same days, me and her ex-husband get our children on the same days. We have them through the same time, the exact same days. His custody arrangement is the exact same as mine. He gets Brody every day after school if Monica drops him off or if he's dropped off on the bus. On his days, he keeps him till the same time I do. She picks up Brody usually before she picks up Journey and then goes home. So I'm not understanding what the issue is if my daughter's telling me one thing and her another thing, but yet it's not an issue for her son to do the exact same thing because they have the exact same custody agreement. I don't feel it's right that I should be a glorified babysitter for her, even though I am her father. I shouldn't be treated like a babysitter, only good enough to have her while she's at work, and that's it. I don't think that's
So,
fair.
All right, ma'am, you entered into this as a stipulation back in April of 2021. Current schedule. What's changed since then?
I've always
Custody or
wanted,
parenting time orders can't be modified unless it's first shown there's a change in circumstances.
I've always wanted her more.
Okay,
But-
that's not a change in circumstances. You entered an order. What's changed in the last 2 years since that order was entered that would
She
necessitate?
now lives in Hesperia.
Sir, now I'm asking her.
Sorry, I was conversing with my mother and my girlfriend.
All right, well, you need to focus on this and not them at this point. What's
Sorry.
changed in the last 2 years?
My work schedule.
What was it 2 years ago?
I was working from 8:30 to 5. Same schedule, but I was not able to, like, I didn't have to work late nights on Wednesdays. And also my daughter coming to me crying, wanting to be able to see her mom more. Like, she's growing up. She wants her
He
mom.
says the same thing. So she tells him she wants. to
I
see
can
him
bring
more.
my daughter in here and you can review with her.
6 is pretty young to talk to the child about a preference for custody of parenting.
Right, but she understands what's going on too.
She's 6.
She's 6 years old, but mentally she's way older than that. She's very,
I don't know
progressed
how you-
on her
I don't know how you
learning.
prove that, but, so when you entered into this agreement, you were working the same schedule except not as late on Wednesdays?
right,
So that's really only one day that's impacted. So what, you get the child on what, Monday and Wednesday, and he gets Tuesday and Thursday, and then you alternate weekends?
Yeah.
So you're really not asking for a change in parenting time either. You're asking for a change in custody. You're asking to go from a joint physical custody situation with equal overnights to you having the majority of overnights. That's actually a change of custody, not a change in parenting time, okay?
okay,
Change in parenting time would be tweaking a couple days here and there, but not changing the custodial parent. Right now, you're both considered share time equally. So I guess my next question would be, let's say I did find there was a change in circumstances since the last order. What do you intend to prove other than the child's preference in favor of your motion? You'd still have to prove by clear and convincing evidence, utilizing 12 child custody factors that it would be in her best interest to change custody. You'd have to prove, that you prevailed on most or all of those factors in order to prove by clear and convincing evidence that custody should change. What would you intend to prove other than what you've told me here today? Because it's going to take a whole lot more than that, even if there was a change in circumstances to carry that burden of proof.
other than like wanting to see her mom more often and be able to come home every night. I mean, yeah, she has a bed at his house. She has a bed at my house too. Yeah, she has to share a bedroom. She has her own toys. She can play with her own stuff. Like, that's not an issue at all. But like, I don't know what goes on over at his house, but obviously something's going on that she's coming to me requesting to come home every night. I mean, I know there's many times I've seen him walking around playing Pokemon Go, so obviously he's not too very disabled, because like she's not, from what she's been telling me, she's not even home with him that often. She's either going to some kind of I don't even know what it's called, like after school. What does she call that?
That would be Miss Frisbee's after-school youth program, and she's only went to that program twice with her cousin, and that was on a Christmas day for Christmas gifts passing, and another time for, it was on her birthday.
It's
She
more
went
than
over
twice
there.
because she tells me when she goes.
All right.
Miss Frisbee
Again,
had the log sign and
are you
sheet.
familiar with the 12 child custody factors that I have to
No.
look at when I determine changes in custody? I mean, it comes down to the ability to provide for the child, the home environment, the family situation in each home. The child's preference is one of them, but that has to be determined whether a child will be interviewed by the court for that. There's a whole litany of things I have to look at. Like I said, even if I find that there's a significant change between 2021 and now, that only opens the door to consider your motion. You still have to prevail by providing evidence that I can plug into all those 12 child custody factors. He gets a chance to defend that. And at the end of the day, I have to make a determination on who prevails on each one. And in order to prove by clear and convincing evidence that it would be in the best interest to change custody, like I said, you'd have to prevail on most of those.
The only other thing that I
know,
could prove would be like the clothing wise, but the food, I mean, she's never hungry. She's always full. I know she has her own room because she shows me, she'll go in the house and she'll show me where her bedroom is or whatever. But it's just, she just wants to be able to, it's not like I'm asking to change a bunch of stuff. I mean, he's still gonna have her every day after school.
But you're taking my
She
night.
just wants to be able to come home and stay with me every night and be with me every night and have more time with me.
Get half the summer, right?
No,
Why not?
Yes,
I'm a working mother.
I mean,
Even through the
you
summer,
share
our schedule is the same. I go to work, he gets her.
I just don't see, you haven't told me what you intend to prove that would sway me to believe that you could prevail by clear and convincing evidence that it's in the best interest, using those 12 child custody factors. So at this point, for that reason, the motion to be denied. Sir, I'm not taking that warrant out of lien.
that's fine.
You
I
need to
will
clear
start.
that up as quickly as possible and pay your support on a consistent and monthly basis.
Yes, sir. I'm gonna go take my
He
crossbow to the pawn
refuses,
shop
like
today.
he's hardly ever pays child support because he refuses to work.
I don't refuse to work. I have no problem with working. My problem with working is I'm disabled. And in order for
You're
me to
not
keep
disabled
this
if you're
job,
walking around White Cloud playing Pokemon Go.
your boyfriend's disabled and he fixes engines for people.
Yeah, okay.
But
And
back to
sells
what I was
vehicles.
saying. What was I saying? I'm sorry. I forgot what I was saying. I got interrupted.
I know, I heard. She needs to stay out of it. It's between you and I.
I was interrupted by you. I'm sorry. I'm trying to remember what I
No,
was
it
talking
wasn't. I
to
didn't
the
say
judge about.
anything.
I'm sorry,
Alright,
sir. I
well,
do not remember what I was talking about.
The issue that was up for today was the parenting time motion. That's been denied. Sir, you need to take care of that warrant and start paying your support. It's ordered.
Yes,
You can't
sir. I
pay,
have
you
a
need to file a
crossbow.
motion to address that.
And what was that?
You can't pay it for whatever reason. You need to file a motion so that can be addressed.
Yes, sir.
You haven't done that, so I expect it to be paid.
I will get on it. I will go to the pawn shop and get rid of my crossbow as soon as I'm done with you. I will try to send in everything that I get for it, and then I will file in that petition for, I don't remember what you said.
You can pay
Change.
the $1,400 bond first and foremost, or
Yes.
I could have Miss Heaven send the police over to pick you up too.
I'm aware of that. I am gonna get on it to pay it this as soon as I can. I'd rather be out of jail spending time with my daughter than in jail where she's no longer able to see
Ashley
me.
Urbis and John Wambo, and both are here via Zoom. This is date and time separate hearing on Ms. Urbis' motion regarding parenting time. Both raise your right hands. Do you both swear or affirm any testimony you give in this cause will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes, sir.
And so, ma'am, you filed this motion. You didn't really say what you were asking for. You just checked the box that said change. What's going on? What are you asking for and why?
I'm not sure what to ask for necessarily.
I'm just tired of the I'm sick excuse every time he's supposed to get his son. And seeing my son heartbroken because his dad's sick all the time, apparently, but never can go get checked out.
Okay. Sir, are you exercising the parenting time that you reported in the order?
I'm doing my best to hold to the order. And every time I've gotten sick, I've went to the doctor. I have doctor's notes and negative and positive COVID tests from when I've had COVID. And I've had COVID 6 times.
Well, that's certainly unfortunate, but, you know, looks like a lot of these dates that the other party has put in would be way more than that even.
There was a few of them that we had agreed upon. Like July 17th, 2021, we agreed to switch the weekend between me and her so that me and my ex-girlfriend could throw a party for her. And then she also told me that if we were sick, she didn't want him over to get sick. You know what I mean? She didn't want us to get him sick.
Yeah, you know, I really don't care what happened back in July of 2021. That's almost 2 years ago. I was looking
I
more
understand.
at what's happened in the last 6 months or so. And, you know, October, every one of your house was sick. December, you had an ear infection. I mean, if you have COVID, you know, that's one thing. You certainly don't want to spread that to your child, but if you've got some other illness, that doesn't necessarily have to be a barrier to you having parenting time. If the two of you were together and you were sick, you'd be parenting the child even though you were sick. You know, the weather, I remember it was pretty bad on the 24th of December. I don't know about the 16th. February 17th,
And
looks like maybe you were or weren't sick. I don't know. And then your girlfriend harassed this party. I don't know. And then on March 3rd, you just said no. And on March 10th, you were sick again, I guess. It just seems like you don't get that much parenting time anyway. You just get every other weekend. Is it still supervised by your parents?
no,
Well, according to the order, it's supposed to be. If the two of you have changed that on your own, I guess that's one thing. But the last order was that you had parenting time supervised by your folks. And, you know, you don't get that much. I guess, is it really that important to you or not?
it is. And I actually want more parenting time if I can get it.
You
I'm
haven't
in a
filed a
lot
motion.
better place now.
You haven't filed a motion to increase it. So all I'm really here for today is to address what the other party has filed. And it sounds like she wants the child to go. I mean, you ask about increasing your parenting time, but you're not exercising the parenting time that you're already afforded. So that's kind of a funny response to the motion. You know, if you're doing everything you can to keep yourself healthy and still getting sick, maybe you need to take that up with your doctor. I don't know. But if you're a sickly person and you get sick, you know, every month or two, you know, that's unfortunate. Maybe it's some kind of thing that your doctor needs to be able to address with you to keep that from happening. I have to assume it's affecting other parts of your life. Do you have a job?
Yes, I do. I'm actually at work right now.
Okay. Are you missing work on all these dates as well?
For most of them, yeah. I've had doctor's notes. And some of the sicknesses, they just say it's a viral infection and they can't tell me exactly what it is.
Mm-hmm.
So I really don't know exactly what it is. And then I'll tell her and that we're sick. It's a viral infection. We don't know what it is and I'm contagious. And there was, she didn't want him to come to get sick if I was sick. So then we tried to work around that. And on December 24th, we didn't get him because of the weather. But then the next day on Christmas, we got him. And me and my girlfriend had a miscarriage the same day.
Okay.
I do need to file a motion because I want to get every weekend. And this past month, I've been trying to get him this past month. And on my 30th birthday, and I've texted her and got no response.
Well, she's not under the obligation to give you any time other than what you're allowed in the order, and you're not exercising that time. You're supposed to have every other weekend, and at least as of 2021 or whenever that order was entered, I think it was supervised. I guess if you go to the doctor every time you're sick, has the doctor given you any suggestions on what you can do?
Yes.
Avoid.
Yep. And she's giving me medicine. She's giving me medicine. The one time I had to quarantine for 20 days. This last time I got sick, she gave me a steroid, a cough suppressant, an inhaler, antibiotics, and that seemed to work pretty good. I'm doing a lot better now.
All right, but that's treating you while you're already sick. Have they given you any suggestions on how to avoid it in the first place? Places to avoid, people to avoid, ways that you can protect yourself so that you're not getting sick over and over again?
She's giving me advice to eat vitamin C gummies or medicine. And the last place I worked at, there was like 250 people there. And I left that job because I kept getting sick. And I felt it was coming from there because they worked directly with China. And we had a bunch of Chinese parts coming in, and it was like somebody was sick constantly there.
Well, I don't know. Ma'am, what, I guess, other than addressing the fact that he keeps getting sick, I mean, I don't know, what do you want? You, like I said, you didn't ask for anything specifically in your motion. You just set forth a bunch of missed weekends. What are you looking for the court to do?
I want him to be able to see his son, but with always being sick and he's not even taking him on the weekends that he should be taking him. And I gave up on asking if he was taking him because every time it was, oh, I'm sick. Or he'd be like, oh, I'm on my way. And then all of a sudden he got sick. And I'm to the point where if you're going to see your son, see your son. But if you're not, if you're going to be inconsistent, you might as well just stay away. And coming from personal experience, I just lost my dad on Friday. I know how it is to have your dad around every time he's supposed to have you, to all of a sudden not having him. It hurt having him there all the time and not having him there. But for me, Brantley, the whole month he hasn't seen him, he'll ask if he's going to daddy's, and I tell him I don't know. I haven't heard anything yet. And then that's it. He don't seem to really ask if he's going to daddy's anymore.
Okay.
I don't know what to exactly ask for without knowing like exactly what the courts could do about it. Because obviously we can't force him to have his time.
Can't really force him. I can suspend his parenting time. It doesn't sound like you want to do that, but.
I mean, if I have to, in order for it to maybe show him that I'm tired of the inconsistency, then so be it. I'm just trying to protect my son's well-being.
Right. I don't know. Sir, what are your thoughts? You gonna try to be a little more consistent with this parenting time?
Yes, sir. I'll do whatever it takes. And I'm sorry for missing all these days. And I really was sick. I wasn't trying to give an excuse out. I didn't want to get my son sick, and I didn't want to send him home to get everybody at their house sick. And I apologize for that. And I know we're not supposed to say anything to each other on here, but I would like to tell her I'm sorry to hear about her dad. He was a good guy.
All right, yeah, that's fine. All right, at this point, I'll adjourn decision on this until July 21st at 9 a.m. We'll hold another hearing, see if things have gotten better. If it has gotten better, then maybe I just dismiss the motion. If not, then I'll have to decide, you know, what type of order would be entered at that point. But sir, if you wanted to file something in the meantime for hearing on the same day, feel free to do so. But I guess keep in mind that if you're inconsistent with the parenting time you've already had, it would be pretty far-fetched to ask for more, I guess. But I guess if it's gotten better, you can certainly file a motion and ask for that. But what's really on the table is addressing mom's motion, unless you file something to kind of piggyback that. All right?
Yes, sir. Thank you.
When was the next court date?
I'll send you an order in the mail, but it'll be July 21st at 9 o'clock. 5-0. Melita, all right, I'll see you guys. Lewis
Thank you.
Johnson, both are here via Zoom, and this is the date and time set for hearing on Ms. Upson's motion regarding support and parenting time. We'll tackle parenting time here first. Can both parties raise your right hands? Both swear or affirm any testimony you give in this cause to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, sir.
All right, and ma'am, what were you requesting to change as far as parenting time was concerned?
Because since Christmas, well, right after Christmas break, I've had Gavin all week and some of the weekends. And so I was requesting parenting time be changed. So because Melissa told me to file for parenting time so I wouldn't be held in contempt of court later.
Melissa, who?
Judge Dykeman, sorry.
Oh, Judge Dykeman did? Okay.
Yes.
So what's the current parenting time order state?
50-50.
And what are you requesting it be changed to?
That Gavin stays with me on the week during the week, and he goes to Lewis's every other weekend.
All right, and sir, you're in agreement with that?
I'm in agreement that Gavin needs to stay with his mom all the time.
So you don't want any parenting time?
No, sir.
Why not?
I'm tired of being bullied and punished by Miss Upson and a 6-year-old boy being manipulated because I'm trying to move forward with my life. Back when Gavin was 2.5 and we had filed for custody in your courtroom, we found out that he was not my biological child. So at that point in time, you had asked me to move forward with what was called an evidentiary hearing, where we would have to prove where it would be in the child's best interest for me to remain in his life, since I wasn't his biological father. At this point in time, Your Honor, it's no longer in the child's best interest for me to remain in his life. Unfortunately, he has been manipulated and misled by his mother, as well as other family members, just to make the time while Gavin is with myself and my fiance hard on him. He's my original reasoning for going for him to stay with his mother was because Gavin was having a hard time going from my house to his mother's house, week on, week off. He was just having a hard time adapting, being in school and everything. And unfortunately, by him hearing adult conversation, his little 6-year-old mind couldn't decipher the difference, and he formed his own opinion towards myself and my fiance in our new life. And it's to the point where Gavin will come to our home and say things towards my new partner, and just do things despising and despite what he knows, and it's just no longer in his best interest. He's been told by his mother that she lets me be his dad, that I'm not his real dad. And that is the truth, Your Honor. I'm not his real father. And unfortunately, I thought I was doing the right thing by remaining to be in his life when he was 2.5, when we had that hearing in your courtroom. Now it's just completely the opposite. Gavin doesn't know whether he's coming or going. He's been led to believe that my partner is a mean person, and he's been told by his mother that she just lets me be his dad, that I'm not his real dad. And that's the truth. I'm not disputing that whatsoever. So I'm going to go ahead and let Miss Upson raise her child in all hopes that she can make contact with the biological dad and hopefully establish a relationship with him. It's just doing more harm than good for me to remain in his life and it's just confusing him and making it hard on myself and Miss Upson moving forward. You know, it's been going on almost 5 years now, and she'll still tell the boy that, you know, she's still healing from us not being together and this and that. And due
Years.
to adult conversation, he's not intelligent enough to form an opinion. He just knows what he hears. So it's no longer in his best interest for me to remain in his life, Your Honor.
All right, order be entered then granting Ms. Upson sole legal and sole physical custody, and there would not be a parenting time order entered at this time. Matter's also been set for child support motion. Ms. Evan, do you have the information necessary to update the support obligation?
I do. So changing it to no overnights. Mr. Johnson would be, it would have one child, $473 child support, $21 ordinary medical, for a total of $494 a month.
All right, what's it set at currently?
Currently, it's set at $53 a month.
All right, ma'am, any further comments regarding support?
No,
Sir?
No, none so whatsoever. What paperwork do I need to file so I can be removed from the child's birth certificate and affidavit of parentage? Because he does have a biological father and I am not it. We discovered that in your courtroom when he was 2.5.
Yeah, how old is he now?
6.
Yeah, I don't know. That time may have passed. There's what's called the Revocation of Paternity Act. You're gonna have to do your own legal research and look into that, but at this point, you're the
Okay.
legal father, so you can certainly give up your rights. When I say rights, I mean your right to pursue custody or parenting time, not necessarily your parental rights in a hearing like this. But you still have responsibilities because he is your legal child based on the paperwork that you signed. The Revocation of Paternity Act may or may not help you, but you're going to have to look into that on your own. At this point, I'll order the support be consistent with the Michigan Child Support Formula, $473 a month support, 21 ordinary medical. And that would be effective the date of service of the motion, 3/16/23. Anything else for today?
No, sir.
All right, Ms. Lair is here. Orders in the mail.
Thank you, Your Honor.
Appearing on a bench warrant. Ma'am, I'm the referee of the court assigned to handle these matters. At the conclusion of this hearing, I'll make a recommendation that'll become a court order. You
Okay.
have the right to have an attorney represent you if you wish. You could hire one, or I could appoint one for you, or you could proceed without and represent yourself. Do you know what you'd like to do?
Yes, proceed without one.
All right, Ms. Evans here from front of the court. Ms. Evans, do you have an update?
I do. Ms. Lauer has a monthly support obligation of $90 child support, $34 medical support, for a total of $124 a month, with $58 ordered on arrears. This support is owed to third-party Monica Youngs. She owes to the plaintiff $5,515.76, state $2,002, fees $389, total owing $7,906.76. We received a $1,500 bond on February 6, 2020. She does have prior contempts. This is a fail to comply issued December 1st, 2020. It's 90 days or a $2,500 cash bond. She was transported here from Meskwaki County on the 9th. And I did talk to Monica Youngs. She couldn't appear today. I know she indicated she was a little frustrated that Monica's not paying the support. However, Monica is working, and I did confirm that. She's working for Stanton Corners Junction Pizza. Talked to Carrie there. That's in West Olive. She's earning $12 an hour. And Carrie did say, you know, she would hold her job. And I did fax the income withholding order. I know we mailed it, but I faxed it today also to corporate. And Jessica indicated she could come up with a portion of the bond.
All right, Ms. Lauer, do you agree that you owe the amount stated by front of the court?
Yes, I do.
And you agree you haven't made a payment in 3 years and 2 months?
Yes. Are you saying as in one lump sum?
You haven't made
Like, I
any.
agree that
Oh,
made a
I agree.
payment.
Yes, I owe that much, but yes, I am able to pay a decent amount of lump sum of that portion.
All right, my question though is you haven't made a payment since February of 2020.
I have been gone. I was out of state, moved out of state and tried work, and living situation up here wasn't that great. Where I'm working now, I got in last year about, a little over a year ago. Didn't fully start working there. A friend of mine passed away and kind of just went downhill from there. It was just a pretty bad last year, I'd have to say. But other than that, I'm working. I'm also in college right now.
Well, but the 2 years prior to that, I mean, well, actually even longer because your last payment was a bond. So you were facing a jail sentence 3 years and 2 months ago and paid $1,500 for a bond. When's the last time you made a voluntary payment? Have you ever made a voluntary payment?
No, I just started working again. So that's definitely in line for that, for
Yeah,
sure.
You're avoiding the question though. Question is, why wouldn't you pay your support unless you're in jail?
It's not that I wouldn't, I just didn't have a job. I guess not up to being myself.
So in 2020,
So not kind of like a lot of stuff. Oh, sorry, go ahead.
in 2020, you made 7 payments. And before that, it was 3 years as well. 2 payments in 2016. And it's been a problem, obviously. You're $8,000 behind.
Yeah, the
Now you've
last
been
couple years
working
been
for a
slow.
year. Now you've been working for a year and you haven't made a payment anyway.
I haven't been working for a year.
But you said you started at this pizza place a year ago.
No. I could have had a job. I didn't fully start this job. And I just reapplied a few weeks ago and started.
All right. What else?
I know that I have made a big drastic change in my life in the last month, with everything that's been going on. Like I said, work, college, good grades, making money. And I'm really not trying to lose my job because I really like the people that I work with and trying not to fall back on my schooling as well.
Where are you going to school?
College Tech University for my bachelor's in science and criminal justice for addiction counseling.
How long have you known you've had this warrant?
A little while, I don't know. Like I've been back for like almost a year, around about a year or something like that, but kind of been moving, flip-flopping too on top of it as well. So now I'm kind of staying with my mom permanently.
And you said you went to Florida for a while?
Yes, I had no place up here to go, so I moved down to Florida.
Where'd you work down there?
A hardware store, and I had been, it would have been last fall. I started working there a couple months, and then a liquor store, like not even a month. And then I ended up moving back up here sometime in end of February, something like that, because ran from an abusive relationship.
Did you notify friend of the court you had those 2 jobs?
No,
Why not?
I have no idea. I do remember calling about something. I know it was something like I didn't know I wasn't supposed to be out of state or something like that. I do know that. Something I didn't know that was an issue or had anything to do with me paying child support and having to stay in Michigan with that.
Why
If
weren't
that
you
is
supposed to be out of
explained
state?
correctly.
Why weren't you supposed to be out of state?
I didn't think that I was able to, because when I talked to somebody, like I hadn't gotten my mail sent to the address up in Manton. So I didn't get the mail up there. So it ended up being some kind of warrant or something like that later on after I had talked to a friend of the court. And I'm not sure if I talked to you, Tricia, or who else I talked to.
So,
Or maybe an Ashley.
So it doesn't matter where you live. As long as you pay your support. I mean, I don't care. You could live in Timbuktu. As long as you're
Right.
paying your support, there's no restriction on where you live. There might be a restriction on where you have visitation with your child or something like that, but you move wherever you want. You're not saddled to the state of Michigan just because you have an open child support case.
Oh, I didn't know. That's just kind of how I maybe interpreted it, and that's how I took it. It wasn't that way.
Yeah. Bottom line is you've had the ability to make payments and you haven't, and it's been for 3 years, and it was chronic before that as well.
I would really like the chance to make a point now that I get paid every 2 weeks. I really like the job. I don't plan on going anywhere. I did a big 180 at the beginning of last month, like big 180.
Okay. So you have the 2,500 to pay then?
I don't have the 2,500. I could definitely have like 1,750.
All right, well, I'm in a position.
And then I can make
I'm
a
not going to
payment.
lower the bond, but I'll give you a chance to call somebody if you need to make a phone call to find that extra 750.
Okay.
Somebody we can contact, Ms. Heaven can contact, or we can get on the phone right now that'll chip in another 750 to put toward that 2,500.
As in like a bondsman? No.
We don't do that for a civil friend of the court warrant. No, a friend, family, someone like that.
Yeah, I can call.
Okay, who do you want to contact?
Huh? It'd be Ken Johnston.
So you've got the 1,750. You want to call him about the other 750?
He has the 1,750.
Oh,
He does.
Okay.
And the rest of it, just to have the whole lump sum of 2,500 is kind of off. Well, it's kind of hard to have that right now without me not having my paycheck until this Friday.
Oh, well, can you make phone calls though, or not?
Yes.
All right. You want me to give you an hour and you can try to get a hold of him, and we'll have you call back into the room and see what you're able to come up with?
Okay. Is
All
there
right.
going to be a straight 2,500 like that I need to come up with, or are you trying to work with me a little bit and see how much more I can come up with?
I'm not going to lower the bond, but I guess if you can come up with 2,500, I won't raise it either.
Okay. Fair
Because
enough.
honestly, your arrears have increased since that bond was set. And at these hearings at times, there's a recommendation to increase the bond. But at this point, if you can come up with 2,500, I won't increase it, but I'll give you a chance to come up with the 2,500 before I just impose it and say 25 and done.
Okay.
All
I
right.
will get right on it then.
We'll get back hold of you in an hour or two, and this is the date and time
And,
set
see
for
what you're able to
hearing
come up
on
All right.
Mr. Weber's motion regarding parenting time. A response was filed and another motion that's actually set for hearing in a couple of weeks, or maybe a week. Has there been any resolution to the parenting time motion at this point?
Not that I'm aware of, Your Honor. I believe Mr. Weber had requested that he have 50/50 parenting time on a week-on, week-off basis, which would essentially be a custody change, given the party's history in the last order. So I'm not quite sure how we could resolve that.
All right, I'll swear both parties in then. Both raise your right hands. Do you both swear or affirm any testimony given this cause will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes.
All right.
Yes.
And sir, you filed this motion. What are you requesting today and why?
I am requesting that the court intervene, and I'm trying to get 50/50 visitation. And I don't believe it's custody because it's not permanent. It'll only be until she starts school. I'm also not claiming any taxes or trying to get any final gain off
Okay,
it.
hold on. Your audio's glitching out here. I don't know what's going on. You started out fine, and then it got choppy.
Okay. Can you hear me now?
Yeah, maybe the closer you are, the better, it seems like.
Okay. Can you hear me?
Yeah, the closer you are, the better it sounds. When you back up, it starts to break up.
Here, let me try if I plug a headphone in and see if this works.
Go ahead.
Okay. You want me to start from the beginning? Sorry. So yeah, I filed the motion to request 50/50 visitation. I don't believe it's custody because it's not permanent. It'll only be until restart school. And
It's happening again. I don't know what's going on. It's happening again.
okay, sorry again.
So you want to go
So-
50-50. You don't see that as a change of custody. Go ahead.
Correct. Yes. Because it's not permanent. It'll only be until Brielle starts school. I'm not trying to claim it on my taxes or any financial gain. It's just visitation. I just want to see her more.
All right. So I guess before I let Mr. Shepherd make a statement on behalf of his client, are you conceding then that the child would go to school and live primarily with the mother when she's school age or not?
Most likely, because we haven't even discussed what school she would attend. I just know that until she starts school, I would like her to be with me 50-50.
And I read the motion that's set for next week. That's got to do with mom moving a couple hours away. Would part of that be the child going to school in, I think it was Lapeer or not?
Yeah, well, that's what she had told me. I was under the previous assumption that she would be going to Rockford, where Kristen works, and Granville was discussed as an option. So,
All right. Well, Mr. Shepherd, what do you want to say?
Yeah, Judge. That's not me.
Not me.
no, not me.
I'm not quite sure who that is. But, so anyway, Judge, as I had previously indicated, the reality in this situation is that this motion is tantamount to a change of custody. There is no proper cause or change of circumstances other than dad would like more. If we open the door on these kinds of motions just because one parent would like more, it would be a revolving door forever. And so this motion in and of itself, based on what he's asking for, has to be dismissed because he hasn't shown what he's required to show, first of all. Secondly, Judge, as we're getting ahead of the game a bit, but that motion with regard to domicile, the parties have joint legal custody, and it'll come up eventually. This child's quite young. We're a few years away, though, on the question. But it kind of goes without saying this child is probably going to attend school where mom lives. Mom is the primary fiscal custodian. She always has been. The last order indicates that. The other thing that I think is important here, Judge, is that there's already, and again, getting ahead of ourselves, there's already about 80 some odd miles between the parties already, home to home. And this additional move is probably only going to add about another 70 miles or so. So these folks are kind of used to that. But it makes sense from that perspective with regard to school. I think the party's intent was, as Dad kind of indicated, that this child would go to school where mom lives, not where mom works. And so with that in mind, Judge, with regard to today's motion, there hasn't been the requisite necessary change of circumstances and or proper cause. So we would ask that the motion be dismissed.
All right. It's kind of hard to decide one motion while totally ignoring the other.
Appreciate that.
Agree.
Because they kind of go hand in hand. There may be some mechanism for increasing Mr. Weber's parenting time, although, sir, what you're asking for to go to 50-50 would be tantamount to a change of custody, because you'd be going from a situation where one party has primary physical custody to where you'd be sharing physical custody equally, and courts have determined that that is actually a change of custody. You've got to show proper cause or change in circumstances to open that door, and then prove by clear and convincing evidence it would be in the child's best interest to make that change. And maybe you can convince me of that, maybe you can't, but the motion to move will be more based on what has happened up until now. It's based on the history. It's based on whether the move has the ability to improve the living situation for the child, but then also The history part is to craft a parenting time schedule that would still ensure that the parent left behind, I guess, for lack of a better term, still can maintain a relationship with the child. And then whether the move is motivated by child support advantage or if there's any domestic violence. But really that looks back at what the parenting time has been and tries to replicate it as best as possible, while also looking at the financial and living situation of the party requesting the move. And I see that set in front of the judge and not me. So I can make a decision today, I guess is my point. And the judge could make a decision that would then render my decision moot or I guess impossible to implement. So really the motions need to be decided kind of together. I guess that was the only reason I asked if I asked Mr. Weber if he was agreeable ultimately to the child going to school with in mom's school district. And he was just because he said he was just requesting an increase of parenting time or even 50-50 until she starts school. I thought maybe that would be
Judge,
starting point for a discussion about what could possibly happen short of having contested proceedings in this matter.
Judge, I can speak to that if it makes sense for everybody. The natural be we are going to replicate and essentially slightly increase dad's parenting time when this move occurs, which is all we're required to do. The idea of a 50-50 relationship is not first off, there isn't a legal reason to consider it. But secondly, it's not even pragmatic given the distance that already exists between the parties and will be somewhat added to. But we've taken that into consideration. And we'll present that to Judge Dykeman next week or whenever we're in front of her. But the reality, Judge, for today's purposes, we would ask that the court render a decision on the motion as filed today. We can address the other issues with Judge as it's currently scheduled. That would be my request.
All right. So, Mr. Weber, what's the change in circumstances or proper cause that would open the door or enable me to consider your motion at this time? What's different now than what was in place back in early 2022 when the order was entered? What has changed, or what overriding factors should be considered in considering the motion?
Sure. Absolutely. I'd like to first point out that she admits to forcing me to reduce the court order without any cooperation, without zero time outside hours of the court. I would not see Brielle. She forced me, keyword, forced me to change that without any consideration. It wasn't an option. It wasn't a choice.
I'm going to have to stop you. So you're breaking up again, and it's impossible to really understand what you're saying here.
Can I call you?
Yeah, I suppose I'll send you a chat with the number to call. I'll put you on speaker.
Your Honor, I do have another 1:30. I apologize. I can hang a little bit late for this one, but I just wanted to make the court aware that I apologize in advance, but I don't really stay much longer.
Yeah, much better.
All right. Go ahead and tell me what you intend to prove then in favor of your motion.
Sure, absolutely. First, I'd like to point out that Kristen admitted that she forced me to reduce my summer visitation. She said that there would be zero cooperation and zero time if I didn't break the court order. Now, personally, I believe that's against policy and Michigan law, policy and procedure, and should be grounds to hear this out. I don't know why we, trying to dismiss something that's so important. I also have many conversations between Kristen and I going back from last summer. I archived our entire conversation, and I have 5 pages with me now of Kristen's word and my word going back and forth. Me asking for more time, getting a little more time here, Kristen denying me time for no reason, Kristen ignoring me. If you'd like, I could read some for you.
some of the agreements and.
Well, I don't know if that's necessary. Let me ask you a question. Did you have the parenting time that you were entitled to in the order or not?
Well, in the order, it says for us to work out a schedule and then to use our policy as like the bare minimum.
No, it says the defendant shall have parenting time according to the Nuevo County Friend of the Court Reasonable Parenting Time Policy Schedule. That's a document that sets forth the schedule during this.
Yes.
During the summer, it's well, I guess with a young child like this, it might be different. But anyway, that guaranteed you certain amounts of time. My question is, did you get the time that the order or the policy guaranteed that you were supposed to get?
No.
All right. Next question then is, did you file any parenting time complaints indicating that you were denied parenting time?
No.
All right, because that's your remedy for addressing that, not coming to me 2 years later or a year and a half later, asking me to change parenting time because you didn't get what you ought to have gotten. Your remedy would be to file complaints. We have contempt proceedings. If Ms. Baker denied you parenting time, I can order makeup parenting time. I can impose a fine. I can throw her in jail if it becomes a chronic issue. But you've got to bring it to my attention that you're not getting the parenting time that you're afforded in the order.
The reason I agreed to it is because Kristen said I would get more time throughout the year for visitation with Brielle if I did it. So that's the only reason why I did it. And throughout the year, it has fallen apart completely, and now it doesn't even hold up.
All right. Well, I don't enforce agreements made between parties that aren't reduced to a court order. You got to understand that. I would have enforced the order as it was written, but you didn't file any complaints. There were no contempt proceedings set. You understand?
Yes, sir. I've also been consistently involved in Brielle's life since birth. I spent the first 8 months at Kristen's house daily taking care of Bree and helping.
Okay. Well, that's good. That's something the judge might be interested in the consideration of the motion to move. But as far as the parenting time motion, I guess I need to know what you intend to prove to increase your parenting time as you've requested.
Well, Kristen, in her own words, gave me permission to get more time on the weekends if I didn't do Wednesday. And she has gone back on that. She has gone back on many of her said words that I have the whole conversation archived. I would love for you to read the whole thing and see it. I have many agreements she has gone back on in her own words.
Okay. All right. Mr. Shepherd, anything else?
All set, Judge. Thank you.
All right. At this time, I'm going to reset this for further proceedings. I will consider Mr. Weber's motion after Judge Dykeman has had a chance to make a ruling on the motion to change residence or domicile. Like I said, they kind of need to be decided together. I guess at the very least, that needs to be decided first before I can properly consider Mr. Weber's motion. Sir, between now and the time I set this for an evidentiary hearing, you can submit any evidence or documentation you want me to consider. Bring it to the courthouse, put it in an envelope, and put it in the file. You've also got to get a copy to Mr. Shepherd so he knows what you plan to introduce. But that would be the way for written documents between you and Ms. Baker or Henry, I guess, to be considered. Okay?
Okay.
All right. So I'll wait and see what happens with the motion in front of the judge. She might set that for another hearing too. If she does, then I'll set this for a hearing after that motion is resolved.
Judge, I can tell you that would be her. What she'll do is she'll hear it. She'll determine there isn't resolution and she'll set it for an evidentiary hearing because it's basically my ship to steer.
Right. And I think probably on a Monday, it's set for 15 minutes, maybe 30.
That's correct.
So the order as a result of this hearing is going to indicate this will be set for further proceedings after determination of the motion to change legal residence. All right?
Judge.
All right. We're all set for today. Yep.
Thank you.
Kristen, I'll give you a call.
Okay, thank you, sir.